And thanks very much for inviting me to attend this forum, to the organisers. Yes, I'm speaking today about qualified privilege. The title of my talk is Qualified Privilege Legislation to Support Clinician Quality Insurance, Balancing Professional and Public Interests. And that title is taken from a publication in the MJA last year that I think a few of you may have seen. So in terms of my background, I'm not a lawyer, but I've had the opportunity to read some legal advice on this issue. I'm a medical administrator by background. I've spent about 20 years in health services and about 15 years in health service management. In particular, I've been a medical director at Alfred Health, and worked in medical training with the PMCV and then at Peninsula Health, so experience in clinical governance, operations, research support, etc. from a health service point of view. Currently, I'm in my 5th year at Monash University, where I'm a professor and head of the registry science unit. So we've heard today really some nice things about registries, which is wonderful. I also coordinate and teach into the Master of Health Management course that we have. Yes, and I am a board director of Better Care Victoria and some advisory committees about registries. So that's a bit of my perspective for this presentation. So I think pretty much everyone in this room does know about registries, but Monash University is the largest operator of clinical registries in the country. We currently have about 32, and these are some of the ones that you may be familiar with. So particularly in high volume, high acuity areas, cancer, cardiac diseases, devices and procedures, trauma, etc. are the areas where our registries primarily are. And in particular, we see registries as a really important part of what we increasingly call the learning health system. So the primary aim, so registries are purposeful data collection, and that's quite different from the use of administrative data for quality improvement, in that registries are clinical data collected for the primary purpose of quality improvement. And also registry data is long-term. A registry is a long-term game. You set it up and you want to look at outcomes and trends in outcomes over the next 5 years, 10 years, 20 years. Some of the longest registries have been going for 40 years or so. They also drive quality improvement for all, and it's really through that cycle of providing audit and feedback and practice change, then providing further feedback and seeing if the practice change has led to improvement or ongoing practice change is needed. And another aim of registries is around safety, and that's generally around devices or hospital performance, or very occasionally sometimes individual clinicians. So what is qualified privilege? So as I said, I'm not a lawyer, but we sought legal advice about this issue because at Monash we had a number of registries, and most of the Monash auspice registries do not have qualified privilege. Monash houses a couple of registries, or supports a couple of registries that are sponsored by the societies that do have qualified privilege. And so we were getting some requests to get qualified privilege for our registries, so we wanted to look into the issue of qualified privilege and how it would or possibly affect the practice of our registries, and what were the implications of having that. So just before we get on to qualified privilege, so how is health data protected? So in a very generic statement, there are a range of national and state privacy laws, and they say that data that you collect from the health system is sensitive, is classified sensitive data, and there are special requirements around collecting and holding this sensitive data and what you use it for and how you store it securely. And one of the main reasons is to safeguard identified information. So to protect identity of individual patients and also potentially of individual clinicians. However, despite a number of regulations, there is still the potential for third-party access to this information, so health data. And I've listed, so FOI, legal proceedings from AHPRA as part of investigations, or as part of investigations from health complaints. So I think most of you would recognise that your medical records can be accessed in this way, and without QP, our national registry data that's collected for quality audit purposes or quality improvement purposes, as other audit activities would be, would also be available to this third-party access. So what is qualified privilege legislation? It was introduced as an amendment at the Commonwealth level to the Health Insurance Act 1973, and the amendment came in 1992. So it's been in existence for nearly 30 years. That's at the Commonwealth level, and in the state level in Victoria, we've had a similar sort of act from 1988. So again, 30 years or so, 25 to 30 years. And the qualified privilege legislation was originally set up for the concept of facilitating peer review of clinical cases by hospital committees, so your traditional M&M morbidity mortality type committee, and allowing cases to be discussed and protect without fear of litigation of the group who were investigating or discussing the cases. So it provides for two main things, this legislation: confidentiality of identified patient and clinician information that's received or discussed during a quality improvement activity, that it can't be accessed or provided to anyone else. And it also, again, protects from civil proceedings the committee members. And the current Commonwealth legislation allows for a declaration of activity for a period of 5 years, at which time the society could, or the auspicing group could, ask for it to be renewed. There are similar sorts of legislations in parts of the US and in New Zealand, but as I think has been mentioned, not in the UK or many parts of Europe. This sort of protection does not exist. So, and I sort of think of it a bit like a cone of silence. So if you've got an activity that's got QP over it, it's like a cone of silence. The information, identified information relating to the activity, can't be provided or broadcast or disclosed beyond that activity or beyond those involved in that activity. The other end of the spectrum might be your sort of full public reporting that we've talked about as well, and that we know happens overseas in countries such as the UK and Europe. So if you think about QP starting with the concept of an M&M committee-based activity, and then we think what's happened over the last 20 to 30 years in terms of the sort of QI and audit activities, and it's really now quite different. And I think even in the presentations we've had today, the sort of initiatives, are now really becoming much bigger. They're now, there's expectations by CPD programs, by Commonwealth, by hospitals, that doctors will participate in quality improvement initiatives, and a range of them. It's expected. Audit is generally a requirement of most CPG programs. There's significant size and scale of activity, and now our activity is not just sort of ad hoc discussions about individual clinical cases, but what we're seeing is with these national audits and registries, we've got high quality data that's collected over long periods of time that can really analyse trends over time. It can drill down to the level of the site or the procedure or the clinician. So we've got a lot more, we've got greater capability in the system to provide feedback to improve outcomes, which is absolutely fantastic. But the type of activities that are undertaking qualified privilege have changed quite a lot over the last 20 or 30 years. So in this paper, and separately, I did a review of the Federal Register of Legislation, which is publicly available. At the moment, there are 29 activities at the Commonwealth level that are qualified or QA declared under qualified privilege as of early February. About 70, and I've just listed some examples here if you can see them, about 75% of them are auspiced by colleges and societies, many under RACMA, some under ANZCA, ONG, other societies, and the remaining 25% are auspiced by other quality assurance groups or universities, particularly for sort of registry or large-scale audit activities. So that just gives you a sense of the sort of activities. There's, as I said, at the Commonwealth level, there's about 30, and there's also activities presumably covered at the state levels as well. I guess one of the things that that needs to be considered, and we've seen examples of this today, is that if you do benchmark performance, or if you do monitor performance over time, you will find variation, and that's just the nature of practice. Particularly when you do it the first time, clinicians will think they're all doing things the same way, but when you actually compare them, especially for the first time or the first few times, you'll find out there'll be some differences. One of the ways that we do compare performance is through funnel plots, and Phil gave a nice example of how funnel plots worked before. This funnel plot is taken from our cystic fibrosis registry, and that's one of the very long-standing registries. Ours in Australia has been going for over 20 years, so you can see there's not very much variation in that. They've been getting these funnel plots and adjusting their performance over time. And this funnel plot also is risk adjusted for age and sex, which are two of the big factors that determine your expiratory volume. So we can risk adjust, and I think that's an important thing to consider in terms of cherry picking and those sort of other downsides of these sort of benchmarking exercises. The risk adjustment process is not perfect, and it can take quite a bit of time to develop the right risk adjustment process that doesn't over-adjust or doesn't under-adjust, and that is fair to clinicians performing in different sites and different sorts of patients and different sort of environments. But essentially what we do see with this sort of activity, once it's repeated over time, is that the variation does reduce, and that's really what we want to see. We want to see improvement in outcomes and standardisation of outcomes. There is the potential, though, for there to be some there is the potential for there to be poor performance, and that is a very small proportion. Joanna Flynn, as part of the medical board, wrote in a paper that about 6% of medical practitioners, probably like the ones we've just heard about, are considered poorly performing. So out of the variation that you tend to see in these funnel plots, a small proportion of it may be due to poor performing practitioners, and that's generally something that you may see sustained as a pattern of care over time. So in terms of the risks and benefits of QP, this is a table taken from my paper, the benefits are significant. It encourages clinician participation in quality improvement activities. It provides a sense of reassurance to clinicians that the information that they're collecting and analysing and reflecting on for the purposes of quality improvement can't be just accessed through freedom of information or a subpoena or some other way. It protects committees who undertake review. It also protects patients from identification. And one of the things that we think is important is it does allow time for development of the risk adjustment and benchmarking methodologies. As I said before, that takes time for them to be developed, to be tested, to be validated. However, on the other hand, we are seeing a shift in public perceptions around transparency and accountability, and there may be a perception, as with any sort of internally managed activity that's not able to be scrutinised, that there was perhaps a lack of transparency. It does prevent activities that have QP to be able to report that 5 or 6% of the poor performing clinician. And potentially it may not motivate increased clinician improvement efforts. And we're finding that these are considered significant downsides by some of the funders of larger registries and audit activities, and that it's not seen to be in the spirit of safe care or patient-centred care. So we're in a bit of a bind at the moment about that. So when we've been discussing the issue of QP among the clinicians and those involved in our registries, this is the sort of perspectives that a clinician will often have, I'm finding. Many of them are interested in contributing to our registries. They're really interested to know how they compare to others. The data collection is a big issue. That's not going to be solved by QP or not, but that's generally people are interested. I find also most people don't really understand data legislation, and I'm not surprised. It's very complex, and many people don't know much about qualified privilege and what it actually means. But as a general rule, they would expect or would not want their quality improvement data, such as registry or audit, to be accessed for those legal purposes, as I've mentioned. They are keen for comparative reports, but on the other hand, if they were notified of outlying performance, not everyone's got a ready mechanism to address this. So particularly if you're operating in a smaller setting, maybe it's a private or a rural regional, or if you're a generalist undertaking specialist procedures and you're not a member of a specialist society, you know, what do you do if you get a report saying that you're an outlier? Where do you go to get that, some support with that? From our perspective as managers of registry activities, and when we discuss among our registry group, you know, we would like to be able to offer QP in many ways because we're very keen to support our clinician engagement. However, we do feel that there's a bit of an ethical dilemma on us because although by asking for QP we don't have to report anything or we don't have to disclose anything, if we do find data related to individuals that is persistently and significantly worse than others, you know, we've got big national registries with hundreds of people participating, you know, we feel as though we're a bit like we'd be sitting on bad data if we were in that situation. So without QP, however, we may not want to therefore provide clinician level reports because they would be discoverable for legal reasons. So we're in a bit of a bind at the moment with this particular situation. We think it's useful, but we think it's also got problems. So my article suggested that perhaps it's time for a review of qualified privilege, and in particular, is there room for some sort of compromise or amendment to qualified privilege? There was a review of the Victorian version of qualified privilege, which was Section 139 of the Health Services Act, and I couldn't find much about it because it was some time ago, but I think it seems to be around about 1999 because this was a response to that consultation, and interestingly Stephen Duckett was one of the authors to that, and he made a comment or a recommendation to this review of the legislation that it should be amended to include information on units or individuals whose performance is below average and the steps taken for improvement. So it wasn't about punishment, it was about how to improve or provide support to people who might fall into that category. And also the AMA Victoria provided a recommendation or a response to this that included there should be available an avenue for referral for appropriate professional, administrative or legal bodies where there was evidence that either a serious offence has been committed or there are serious and continued variations in performance from what would be regarded as an acceptable standard of care. Then there was a review a couple of years later, but in the Commonwealth legislation that the Australian Council at that time, not the Commission, but the Council for Safety and Quality in Healthcare proposed as well. And again, in their review, they wrote, I think, perhaps taken from the AMA submission, that if there should be appropriate professional referral to administrative professional legal bodies if there are serious continued variations in performance. So this is back in 2001. So it's nearly 20 years ago, and I'm not aware of any further reviews or consideration of this issue. But it is coming up in the discussions that Sally Rayner is leading around developing a national strategy for qualified privilege. So what are the options for QP going forward? So in my view, the overall aims of quality improvement activities such as registries are to improve the quality of care for all, and we see that through a reduction in variation and a greater standardisation of practice, which, as Stephen said before, leads to better quality of care. There are a very few people that could also, that may also be impacted. It may be devices, or it may be sites, or it may be individual clinicians that actually have significant safety issues. But on the whole, the aims of quality improvement activities such as registries are to improve care for all and clinical practice for all. I guess the issue that we face is, should entities that auspice large quality improvement activities be able to report or disclose substantial clinician performance issues? And in my paper, I only suggested that it was disclosure to the hospital, which the practitioner is practicing. And as we've heard, potentially they are able under QP to already make a disclosure themselves, but currently we're not able to make a disclosure, just like VASM itself is not able to make a disclosure, or to a college or society. They're the only sites that, or bodies that we were proposing to make a disclosure to. So at the moment, I think the options are that some activities are happy to continue with no clinician comparative information. So I know our cardiac registry just reports at a unit level or site level, and I think a number of other registries do that as well. And I actually think that's a really useful way to do things. And I think that there's still a huge amount to learn by reporting at site level. We've seen lots of funnel plots and things about sites and how hospitals compare it. I think that's very useful. That does limit the potential engagement of individual clinicians if they don't get their own report back. Another option that I understand the National Joint Replacement Registry is doing is that they have a peer-to-peer sort of mechanism whereby people, clinicians or orthopaedic surgeons that are participating in the Joint Replacement Registry can share reports and discuss them themselves, because they're all sort of within the kind of silence of the activity, and so they are able to do that. They haven't produced any data yet, as far as I know, about how that's improving outcomes, but they will and they intend to. Or is there the capacity to potentially revise the qualified privilege legislation to allow for some limited disclosure for safety purposes where there are persistent and significant outliers, and should that be specific to registries, or should that be for all activities that use QP? So that's probably my preferred. And then lastly, I just sort of say, what is the role of colleges and societies in managing performance? And I would like to note the leadership of RACs in this area. Certainly we have a number of our registries are surgically related, and we've always got great engagement by RACs in supporting the registry activity and participating in committees in doing whatever they can do to facilitate and support engage their membership in our registries, which is wonderful. Not yet the same for all the other colleges, so you're leaders in this area. But essentially, the things that I see, RACs doing that I'd like other colleges, I guess, to do is to support and lead these activities, to potentially develop policies or procedures about their membership and around performance issues in consultation with their membership. Obviously seek to prevent or identify performance issues via training and review, CPD, all those things that you do currently, and collaborate with other bodies with roles in clinician performance management. It sounds pretty straightforward, but there is great variation in the way colleges approach this. So that's really all I wanted to say. I hope that's enlightened you a little bit more about this issue and some of the perspectives on it. I'm happy to take any questions.